Confidential sources are probably the one area where most journalists get into the most trouble. Uh, we use the term anonymous sources in journalism. Generally speaking, in the law, it's either confidential sources or unnamed sources, but they essentially mean the same thing. So it goes back to the issue of what's called privilege. An absolute privilege involves doctor-patient relationships, lawyer-client relationships, or confessor-penitent religious um, advisors and their advisees. And that means that the courts cannot force the doctor, the lawyer, or the confessor or religious individual to testify in court. Qualified privilege involves reporter and confidential sources. There is a history of privilege. 1855, the New York Times was found in contempt of court when J.W. Simonton refused to testify about a story he wrote alleging that a congressman had solicited bribes. He later testified. 1873, an editor of the New York Tribune was subpoenaed to appear before a New York grand jury. He refused and was found in contempt. 1959, in Garland v. Torrey, the U.S. Court of Appeals for the Second Circuit refused to exempt a reporter from testifying before a grand jury. The appellate court recognized that compulsory disclosure of a journalist's confidential sources of information may entail an abridgment of freedom, but that the right of an individual to a fair trial trumped the First Amendment in this case. Again, Branzburg v. Hayes. In 1972, the court decided by a 5-4 vote that the First Amendment does not provide journalists with the right to be free from testifying before grand juries, to testify about criminal activities. And that's the law in the federal courts. In Branzburg, it really put together a whole variety of courses. So Branzburg of the Louisville Courier-Journal wrote about drug use in 2 separate cases. Paul Pappas, a newsman photographer from a Massachusetts television station, gained access to the Black Panthers. Earl Caldwell of the New York Times covered the Black Panthers. Branzburg and Papper lost in the lower courts. Caldwell won in the appeals court. But when it came to the Supreme Court, Justice White declared that the general obligation of a citizen is to appear before a grand jury or a trial, which outweighed privileges that journalists claimed. Simply put, as I've said throughout most of these lectures, journalists really have no more rights than individual citizens. In the court dissent, however, in Branzburg, Justice Stewart provided a 3-part test, and this became important in terms of future litigation. So there's need for probable cause that the reporter had obtained relevant information. The information cannot be obtained in any other way, and that there has to be a compelling and overriding interest in the information. So qualified privilege on the federal basis, okay? The type of proceeding in which journalist is ordered to testify. A lot of times it's grand jury. The type of information the journalist is ordered to divulge. If it's non-confidential information, it's very difficult to protect. And there is a determination of whether the individual is qualified as, quote-unquote, a journalist. And the Attorney General issued guidelines in 1973 that a prosecutor must not impair a reporter's responsibility to cover a story. There's also qualified privilege in states. So nearly all states in the District of Columbia have varying degrees of qualified privilege for journalists. The Pennsylvania law happens to be rather strong. The protection varies and often may not cover freelancers and bloggers. And sometimes there's absolutely no protection when a journalist is being subpoenaed in a libel case against himself or herself. Newsroom searches. In Zurcher versus the Sanford Daily, the Supreme Court found that the police had conducted a legal search of the newspaper's office to find items. The court determined that the Fourth Amendment are directed at places, not individuals. The Privacy Protection Act of 1980 essentially was passed by Congress to limit newsroom searches like that at the Stanford Daily. The exemptions: if a journalist is suspected of a crime, if there's the possibility of imminent death or serious injury without the information, and if there's the possible destruction of documents by the news organization. There are a variety of recent cases, and one of the most interesting ones in recent years was the leak from the Bush administration that Valerie Plame was a CIA operative. Scooter Libby was found guilty. He worked with the Bush administration of perjury when, even though he was not the one who leaked the information. Some journalists agreed to testify, but Judith Miller refused and she went to jail. The Boston Globe decided to pay $1.6 million in a libel case rather than to reveal the sources, and a variety of news organizations agreed to pay $750,000 to Chinese scientist Wen Ho Lee rather than to reveal the sources of information that he was suspected of being an agent of China. So what should you do? You need to determine your news organization's policy on confidential sources, if there is one. If there isn't one, you need to look at the various ethical standards, the Society of Professional Journalists, the Associated Press, with respect to confidential sources. SPJ, for example, says identify sources when feasible, question the motives of sources for seeking anonymity, clarify the conditions in which you granted anonymity, and keep your promises. Having said this, reporters get into problems all the time with the use of confidential sources, not only in libel cases, but also with the general public, because the credibility of the information is seen to be lower unless you can provide the information. So be careful when you are using confidential sources. So that's all there is for today. I thank you very much, and we'll see you again online.